Okay. Hi everyone. Welcome back to the current legal affairs series Vidhi-Nama, which is dedicated to the discussion of current legal news for your examination. We have already done the news from January 2026, which is already available on YouTube. If you have not watched it yet, please go and watch it. Entire legal affairs coverage from January 2026 is available. Now we come up with Feb part 1. This is the legal news covered till 15th of February. Okay. And again, we're going to do the most important topics, the relevant concepts of law from that, which you can potentially get as passages in the examination or maybe legal knowledge questions, because now even the legal knowledge questions are coming up as per the latest trend. So it's a very, very important session. If you have not subscribed to the channel already, please do that so that you never miss such sessions in future. And also share this link with your friends or group and other people who are also preparing for CLAT, because it benefits everyone. Okay. Now starting with the first part, like I said, the first news that we have is of extradition. So recently, what has happened that Abu Salem has been extradited from Portugal to India for the 1993 bomb blast. So he's a terrorist and accused in the 93 bomb blast, and he was in Portugal. Now he has been brought to India. Okay. Now, so the news, because the case is pending here, he committed the crime here, so he's going to be prosecuted here in India. Now, the question, the larger legal concept, which is important for us to understand, is what exactly is an extradition? So it's an international process, where you bring back a certain accused to a country where he committed crime. For example, Abu Salim had committed crime in India, right? And then he ran away to another country, or he was hiding in some other country. So extradition is the process with which both the governments or the governments of both countries collaborate and help each other, where they successfully bring the accused back to the country where he committed the crime. So that's what extradition is called, and it's a concept in international law. Okay. But what is important for extradition is that it's got some conditions attached to it. For example, in this case, the central government had promised that there'll be no death penalty to Abu Salim for his involvement. That's one condition on which Portugal has agreed to send him to India. Number two, that there will be no imprisonment beyond 25 years. That again is a commitment which has been made by India, right? And apart from that, there are other things also in extradition that we need to know about. First is Extradition Act, which is 1962. So yes, this potentially becomes a legal knowledge question. They can always ask you that, under which law extradition is covered. So the right answer is Extradition Act 1962, and which says, in particular, Section 3, Clause 1, we have, which says it enables application of extradition treaties by notification. Uh, Now, what is a treaty? So extradition treaty is an extradition agreement in general. You know, in normal sense, two parties have a contract to deal with each other. For example, there can be a tenancy or a landlord agreement. So we normally call it an agreement or a contract. But when we talk about international contracts, so it sometimes can also be said to be a treaty. That's why we call it extradition treaty. ओके. सो सेक्शन 3 के अंदर इसकी बात हुई है. लिमिट पनिशमेंट हैज बीन लिमिटेड, बट दे डू नॉट कंट्रोल रेमिशन अनलेस एक्सप्रेसली स्टेटेड. Remission means completely letting somebody go free. Completely letting somebody go free, reducing amount of punishment, letting him go free, acquitting after, not acquittal in pure legal sense, but yeah, when the term is reduced, let's say from 10 years to 5 years, so that's remission, of course. तो ये एक्स्ट्राडिशन एक्ट, इंपॉर्टेंट चीज क्या क्या आ सकती है लीगल नॉलेज के अंदर, नाम पूछ सकते हैं कि कौन से लॉ के अंदर ये मेंशन्ड है. सेक्शन आई डोंट रियली एक्सपेक्ट कि वो पूछ सकते हैं, बट जस्ट कीप इट इन माइंड. And then there are certain provisions to this. Let's move ahead and see. There is a doctrine called speciality, doctrine of speciality. So that says that you can only try for offenses approved by the extraditing state. Now, what is an extraditing state? The state which has, which has sent or which has deported the accused to the country, to the other country. That's called extraditing state. So here, extraditing state is Portugal, and very very important that you can try in India Abu Salim only for the crimes which have been approved by Portugal, and you cannot add any other crime, other than the ones which have been specifically approved. Okay, so that's one condition on which the state transfers or deports a criminal back to its country. And then the execution is governed by the domestic criminal law. Whatever you have all rights with respect to punishment की जो Indian law के अंदर whatever crime he might have committed, how much punishment has to be given accordingly, वो सब Indian law, domestic law के हिसाब से Indian government can apply. ठीक है? So I hope things are clear. Bit about extradition law. It's an international law concept, and in many cases, many countries have engaged with this process for a very very long time by now. Okay, so more on this we will come up whenever there is need to elaborate more. The next issue in hand is Sabrimala issue. I hope if you are in the habit of reading legal current affairs or even current affairs for that matter, so you would know what exactly is Sabrimala issue. In 2018, early 1819, there was this judgment called Sabrimala judgment. What was the main concern revolving around it was that women were not allowed entry into Sabrimala temple on the ground of certain health related issues. So at that moment, the Supreme Court had said that women have right to enter Sabrimala temple like anybody else, and that there is a fundamental right to equality. That there is a fundamental right to freedom of religion, and how you want to execute it. So the judgment had allowed women to enter into the temple, but the issue remained that a lot of petitions challenging the judgment were filed on various grounds, along with some other issues also, like the ones which are mentioned here. So the Supreme Court has decided to refer this matter to a nine-judge constitution bench. Now, what is a constitution bench? First of all, Supreme Court, when there are five or more judges, when there are five or more judges in Supreme Court on a certain matter, which is related to constitution, that's called constitution bench. Minimum is five or more. So it's a nine-judge bench. Okay, and they're reviewing the judgment because they've already given the judgment. So now they will not be hearing the judgment from starting from scratch, but they're only going to review whether the judgment is right, lawful or not. Okay, so that's the background of this judgment. Important expected questions is what is a constitutional bench, and how many judges were present in the Sabrimala review case? What is a Sabrimala temple dispute? They can ask you all of that in legal current affairs, knowledge-based questions. Also, you can expect a good passage related to this judgment, connecting it to Article 14, 9, and 21 also. Now, this, like I said, this review is not going to be limited only to the Sabarimala discussion. It's going to be much more beyond than this. So it will also include issues like entry of women in mosques or in dargahs in general, which is also banned and prohibited. Then entry of Parsi women in fire temples. Then practice of excommunication and FGM, that is female genital mutilation among Daudi Bohra community. So all of these issues are going to be now, referred to the nine-judge bench of the Supreme Court, and soon we will see what judgment comes up. According to that, we will update our information. But yeah, keep this in mind and follow this news for better understanding. Now, how you can get a passage related to this? I said that it's a temple, it's an issue related to temple. So essentially becomes a religious dispute. So whenever we talk about a religious dispute, naturally Article 25 will come into picture, which talks about freedom of religion, and it has given the right to people on an individual basis. So there are what are the rights with respect to religion? First point is important. Article, the name, the number of the article is very, very important. Article 25, right to profess, practice, propagate, and freedom of conscience. Four aspects are there. Understand, there are four aspects to this right: conscience, profession, practice, and propagation. Okay. Let me tell you the meaning of each aspect. So conscience has got something to do with your inner belief. You know, you may be wishing to be belonging to a certain religion. You may be uh, inside you may have faith. Yes, it's about inner faith towards with respect to a certain religion. Then to profess, as in what religion you want to adopt. Then to practice is again what religion you want to, religious ceremonies and rituals you want to practice on a daily basis, on occasional basis. And propagate is to spread the teachings of that religion. So there are four aspects. There can always be a good legal GK question that under Article 25, how many aspects or what all kinds of aspects are there. Okay, so you have to remember conscience, profess, practice, and propagate. Article 25 के अंदर है. At the same time, there is also a restriction which is subject to. So we know that all fundamental rights are subject to some limitation, some restriction. We cannot say that there'll be a right which is unlimited or which has no boundary, which has no limits. It's not like that. There'll be a limit set after a certain extent. So the limit of Article 25 is public order, morality, health, and other fundamental rights. So wherever the government, the legislature, or the courts feel that a person is disturbing public order, morality, or health, or other fundamental rights in the name of his own fundamental right under Article 25, or in the name of right to religion, then his right can be curtailed to an extent which is necessary. जितना भी जरूरी होगा, जितना भी नेसेसरी होगा, उतना राइट कर्टेल किया जा सकता है, रोका जा सकता है. दैट इज द रेसिकल 25, विच इज ऑल्सो नोन एज रीजनेबल रेस्ट्रिक्शन इन द आइज ऑफ लॉ. Okay, but one thing is to be noted, that there are very, very restricted grounds. We just see four grounds here. Okay, it is not a general restriction. That is to say that your right cannot be restricted on any random basis, on any random ground. Okay, specific grounds have been mentioned on, and only on these grounds, Article 25 can be restricted. Number one. Number two, the number of restrictions and the kind of restrictions also depends on which fundamental right we talk about. For example, in Article 19, we have a lot of grounds on which Article 19 can be curtailed. Then, in Article 23, 24, and so on, we see the number of restrictions keep varying. Okay, so don't be confused, or at least don't be under this misconception that all fundamental rights have exact same number of restrictions or kind of restrictions. No, that's not true. Completely depends on the kind of fundamental right that you are talking about. Okay, so this holistic approach is absolutely relevant for all of you to understand and be able to comprehend any passage related to these fundamental rights. Okay, if you have any question, you can ask me in the live chat and I'll answer it right away. Otherwise, then we proceed. Yeah, so the central issue, like I said, is whether the exclusion of women violate individual religious freedom and equality. Okay, if you don't allow a certain woman or a section of women from entering into a certain temple or into a certain place which is meant for public, okay, then what are the implications? What are the consequences? That's going to be examined by the Supreme Court's 9-judge bench under the review petition against Sabarimala judgment. That's the entire thing. Okay. If you're taking down the notes, excellent. I would definitely suggest that you pause it wherever you want and then take down necessary points, relevant points in your notebook. And it would be even better if you are actually able to maintain a separate dedicated notebook for current legal affairs. That works the best. Okay, but whichever way, it is your choice. Yeah. Now, Article 25 was there, which talks about individual right to religion. Okay. Now there is Article 26 also, which talks about right of religious denominations. Denominations would be religious, you can say, organizations or structures, right? So it grants denominations the right to manage religious affairs, manage the institutions. Again, the restrictions are based on three grounds. Okay. And so if Sabrimala is considered to be a religious denomination, then what is the autonomy that it enjoys? And to what extent that freedom or autonomy exists, that again is going to be discussed in the review case. Okay, so one prime difference between 25 and 26 is that 25 is aimed at individual religious liberties, and Article 26 is aimed at collective or organizational religious liberties, right? Both the questions you can very well expect in the legal knowledge section of Clat. Now we talk about judicial review of religious practices. So, firstly, what is a judicial review? Whenever the courts or the judicial system looks into the validity or legality of something, some maybe some past order or a law, etc., that's called judicial review. ठीक है, सो जो सुप्रीम कोर्ट यहाँ पे करने वाला है, दैट इज पार्ट ऑफ जुडिशियल रिव्यू. ये सुप्रीम कोर्ट का पावर होता है टू हैव जुडिशियल रिव्यू. Even when the parliament makes a law, the courts have got complete rights and powers to check or examine the legality of that. Now, when it comes to religion, there is this concept called essential practice to religion. If there is anything which the court feels is essential to the religion, then the court normally does not interfere with that. Does not interfere with that. Okay, so in past also, wherever the courts have interfered with religious practices, religious freedoms, you will see that those practices were not considered to be essential practices. For example, the prohibition of triple talaq, instant triple talaq, that was declared void by the Supreme Court because it was not considered to be an essential practice. There is a clear law against dowry. So again, dowry is not considered to be essential, and that's why there's a law against it. As simple as that. So whatever is not essential to the religion, the government can interfere with that, can restrict it if it violates fundamental rights. But as of now, the real position is that when there is a certain essential practice, like the practice of praying in itself, offering puja prayers to the respective gods, that's a practice which is essential in itself. The government or the laws do not interfere with that. Okay. Anyway, now coming to the next concept, which is about bail. I want you to first go through this slide on your own and try to understand what it is, then we'll understand. Okay, so bail, we all know that when a person is in the custody, when he has been taken into police custody, then he might be released from the custody for some time, for a longer period of time, depending on the court order. Okay. And well, when the case is going on, so two things are happening. When the case is going on in the court, and that person is out on bail, that is to say, he lives outside, but then he has to report to the court again and again, time to time, whatever is described. So, bail is a partial freedom where you get to live where you want to live, but still be accountable to the case which is going on. Now, bails are normally of two types. Number one is when a person has been arrested. Most of the bails are of this kind, a crime was committed, person was arrested, put behind the bars or put into the custody, and then he requests for bail. So that's called regular bail. In most cases, that's what really happens. But then there is another kind of bail which is known as anticipatory bail, which is derived from the term anticipation. And anticipation refers to when you are expecting something to happen, when you anticipate some event to happen. And so when a person, even when he has not been arrested, he has not been put behind any bars or put into any custody, but he has apprehension. He is anticipating that he might be arrested in future, maybe tomorrow, day after, or next month, whatever. अगर उसके पास ये बिलीव करने के लिए रीजनेबल ग्राउंड है कि उसका अरेस्ट हो सकता है, तो अरेस्ट होने से पहले अरेस्ट होने से पहले वो कोर्ट में जाके और मांग सकता है बेल। दैट इज कॉल्ड एंटिसिपेटरी बेल। ठीक है। सो या, एंटिसिपेटरी बेल इज एसेंशियली अ बेल which is granted to a person even before that person has been arrested. If he is granted bail after getting arrested, that's called regular bail. तो एंटिसिपेटरी बेल के अंदर क्या बात हो रही है? पैरिटी रेफर्स टू इक्वालिटी। ओके, इसमें कोर होल्डिंग क्या है कि प्रिंसिपल ऑफ पैरिटी कैन नॉट बी इन्वोक्ड बाय एन एब्सकॉन्डर टू सीक एंटिसिपेटरी बेल बी merely बिकॉज को अक्यूज्ड वर एक्विटेड। सो लेट मी एक्सप्लेन कि इसमें बात क्या चल रही है। लेट्स से देयर आर टू पर्संस ए एंड बी हु कमिटेड थेफ्ट इन अ हाउस। ठीक है। अब उनमें से वन ऑफ द पर्सन वाज कॉट एंड इज बिहाइंड द बार्स, इज इन द कस्टडी। द अदर वन एब्सकॉन्डेड। एब्सकॉन्डेड का मतलब हो गया कि वो भाग गया। ही इज ट्राइंग टू इवेड अरेस्ट। Okay, he has escaped from the custody or from the police authorities. तो वो absconder है। नाउ अगर जो ए है पर्सन जिस जो अरेस्ट हुआ था, उसको अगर बेल मिल जाती है, ठीक है, तो जो एब्सकॉन्डर है, जो भाग गया था, वो केवल इस बेसिस पर बेल नहीं मांग सकता दैट माई को अक्यूज्ड हैज बीन गिवन अ बेल। राइट। He cannot ask for bail merely on the basis that my co-accused has been given a bail, or at least that he was acquitted in other matters. So let us say A was acquitted and B was absconding. He went to some other country or some other state. Then you got to know that even A has been acquitted in that case. He surrenders and says that okay, I need bail because my co-accused has been acquitted. So the court will say that no, because you have deliberately evaded the investigation and trial, and therefore now you can't come and benefit out of it. Either you had supported the investigation, you had cooperated with the police authorities, then yes, we can say that okay, you deserve some kind of concession or relaxation. But then you were evading arrest consistently and you have provided no support to the police authorities, then you cannot come and claim equal rights. Parity refers to equal rights. You cannot claim equal rights with that of the person who did support in the investigation. Okay, so this is the news, but the news is not so important. What is important is the legal issue which is involved in this news. We have anticipatory bail in the BNSS or in the CRPC also, which is Criminal Procedure Code Section 438, now has been replaced by Section 482 of BNSS, that is भारतीय नागरिक सुरक्षा संहिता। ठीक है। तो ये सेक्शन आपको याद रखना है, पुराना वाला नहीं याद रखोगे चौके, बट नया वाला जो सेक्शन है दैट इज सेक्शन 482 ऑफ बीएनएसएस, ये आपको डेफिनेटली याद होना चाहिए बिकॉज एंटिसिपेटरी बेल बहुत ज्यादा न्यूज में होता है लीगल के अंदर। यू विल फाइंड इट वेरी वेरी ऑफन, कोर्ट्स टॉकिंग अबाउट इट। सो प्लीज अंडरस्टैंड एंड रिमेंबर दिस प्रोविजन ऑफ लॉ। ऑलरेडी मैं बता चुका हूं कि ये एक डिस्क्रेशनरी रिलीफ है, मतलब ये इट इज द डिस्क्रेशन ऑफ द जज। आप इसको एज अ मैटर ऑफ राइट क्लेम नहीं कर सकते। यू कैन ओनली मेक अ सबमिशन, ओनली मेक अ रिक्वेस्ट टू द जज, एंड इफ द जज फील्स दैट यस यू हैव अ पॉइंट that you are anticipating arrest and you will be wrongfully arrested even when you have committed no crime. If you are going to be wrongfully arrested, अगर आपने ये जज को कन्विंस कर दिया, then at his discretion you might get this bail। ठीक है। लेकिन इसके लिए क्या चाहिए होता है? दैट गुड फेथ ऑन योर पार्ट, गुड कंडक्ट ऑन योर पार्ट, एंड इफ यू कॉपरेट विद द इन्वेस्टिगेशन, यू प्रॉमिस टू कॉपरेट, देन द कोर्ट एट इट्स डिस्क्रिप्शन माइट गिव यू एंटिसिपेटरी बेल। Right? So what is important is two things, three things you have to understand and retain. Number one is the section. Number two is what is an anticipatory bail. And number three, in what conditions or upon what conditions anticipatory bail can be granted. Okay. Now you can just go through this. It's already explained by me. Just check it once again. ओके, ये ऑलरेडी हो चुका है. नाउ द नेक्स्ट लीगल इंफॉर्मेशन दैट वी हैव इज द तलाक ए हसन. एंड जिसमें सुप्रीम कोर्ट ने रिसेंटली इंटरवीन किया है, तो कोर्ट ने क्या बोला है. मुस्लिम टाइप ऑफ डिवोर्स. सबसे पहले तो एक ऑपरेशन जो जो एक तलाक हसन वाज प्रोनाउंस्ड बाय अ मुस्लिम हस्बैंड अगेंस्ट द वाइफ, उसको रोक दिया है. देयर इज अ स्टे अगेंस्ट इट, मतलब दैट विल नॉट बी ऑपरेटिव, विच फर्दर मींस दैट दिस विल नॉट बी अ वैलिड divorce, will not be considered to be a valid divorce by the Supreme Court. And then they have declared that parties are validly married unless there is a different order coming from the court. और फिर वो एसएचओ ने उसको बोला है कि अरेस्ट करना है, कस्टडी में डालना है, दैट्स अ सेपरेट स्टोरी. बट व्हाट हैज हैपेंड नाउ एटलीस्ट इज दैट देयर इज अ डिस्प्यूट रिवॉल्विंग अराउंड तलाक हसन. कि ये क्या होता है, ये हमें समझना होगा. यहाँ से क्वेश्चंस आ सकते हैं. एंड अ बिट मोर क्वेश्चंस रिलेटेड टू दिस कॉन्सेप्ट. सो लेट्स सी. कोर्ट ने देखो इंटरवीन किया क्यों? बिकॉज द वाइफ वाज इलिटरेट एंड इकोनॉमिकली डिपेंडेंट ऑन द हस्बैंड. So talaq Hassan is, you have to get consent of the wife also for this kind of divorce, and the wife was not in a position to express consent in a written manner. Okay, understand? Because there was this allegation that the husband has obtained signatures on blank papers. The husband gave her the blank papers, maybe asking her to sign because of some other reason, that probably the husband said that the document is for a certain purpose, for X purpose or Y purpose, but the purpose was different clearly. So that was the allegation, and on that basis, the court had to intervene to make sure that the divorce is validly executed. The process of divorce is also very very important. ठीक है, तो उसमें the courts have held that extrajudicial personal law practices are not immune from judicial scrutiny. That is to say, again, we talk about judicial review. तो अगर कोई पर्सनल लॉ है, रिलीजियस लॉ है, मैट्रिमोनियल लॉ है, हिंदू लॉ है, मुस्लिम लॉ है, वो भी जुडिशियल एम्बिट से या जुडिशरी की एम्बिट से फ्री नहीं है, इम्यून नहीं है. ठीक है. और इन व्हाट केसेस द कोर्ट विल सपोर्ट द वाइफ is when the consent is doubtful, which in this case is because I said the wife is not is not independent, is not literate. So there is more possibility of her having been duped by the husband. In this case, when the process appears to be unilateral or coercive, which also appears to be one such case in this situation. Or otherwise we can say that the divorce was okay, but it was not executed properly, it was not delivered properly, so that also remains an important aspect. Like I said, you should make notes, you should take down anything and everything that you think is important, and for you to remember, uh, that will definitely be of great benefit when you revise everything in the end right before the CLAT examination. These things will help you a lot. Okay. So what is the kind of divorce? Like I said, this is important. Talaq is three pronouncements during successive tuhur, that is periods of purity. Periods of purity refers to the period between two menstruation cycles. That's called the period of purity or tuhurs, and these pronouncements are made during that period. Okay, why there is a need for three successive pronouncements? Because sometimes the pronouncement of talaq or divorce is taken in a haphazard manner, and therefore the husband is provided an opportunity to reconsider what he's going to do. So he's got three chances, and if he does not avail any of the chance, that simply means that yes, he wants to go ahead with the divorce, right? But but this kind of divorce is only valid when there is a due process which is followed, when there's a good intent and absence of any kind of coercion, तो ये वैलिड हो सकता है. ठीक है. So I don't really expect legal passage on this, but I definitely expect legal knowledge questions revolving around this concept. Uh, and during the course of our lectures, of course, we will get into more kinds of divorces in both Muslim law and Hindu law also. But for now, that this information is definitely important for all of you. Now, how is it related to the Constitution? Article 21 and Article 14 and 15. So Article 21 से related कैसे है? Because it talks about right to life and dignity. Okay, जिसमें लिखा है protection against arbitrary marital dissolution, illiteracy, dependency, coercion directly implicate dignity. तो Article 21 में देखो mainly जो the umbrella term in Article 21 is right to life and dignity, जिसके अंदर कवर होता है right against arbitrary marital dissolution. See, it's an interesting legal concept that right to marry, right to reproduce, right to have physical relations, right to have personal intimate relationship with somebody, or even right to dissolve a certain marriage or relationship is also a part of Article 21. So when you talk about dissolution, the right to dissolve the marriage should not be available arbitrarily to one party. मतलब उसमें unequal power नहीं होना चाहिए. So the court has to give equal rights to both the parties, in other words. So to make sure that happens, Article 21 is there to protect the wife or husband in that case. If there is if there is an allegation coming from the husband, then the court will obviously look into that also. But yes, there is this connection to Article 21 for sure. And how about Article 15 and 14? Like I said, because whenever there is a dispute of equality, discrimination, then naturally these articles come into picture. So Article 14, 15, and 21 are the most basic legal provisions with which this concept of talaq-e-Hasan is connected. Okay. Now, there is no compulsion to continue an unwanted pregnancy. Okay, so this is about MTP Medical Termination of Pregnancy Act. एंड इसके अंदर कोर्ट ने बोला है कि जो मेडिकल टर्मिनेशन है वो एक 30 वीक प्रेगनेंसी को कोर्ट ने अलाउ किया बिकॉज द गर्ल वाज माइनर. नाउ ऑल्दो दिस इज अगेंस्ट द रूल बिकॉज नॉर्मली मोर देन 24 वीक्स इट्स नॉट अलाउड, लेकिन फिर भी कोर्ट ने यहाँ पे अलाउ किया है कंसिडरिंग स्पेशल सर्कमस्टांस दैट द गर्ल इज अ विक्टिम माइनर. ठीक है. और ठीक है, जो जजमेंट है वो यही है कि यू कांट कंपेल अ वुमन फॉर अनवांटेड प्रेगनेंसी एंड रिप्रोडक्शन ऑटोनॉमी लाइक आई सेड इज आल्सो पार्ट ऑफ आर्टिकल 21. ठीक है. तो उसके अंदर ये आता है, लेकिन हाँ मोर स्पेसिफिकली वी हैव अ लॉ विच इज मेडिकल टर्मिनेशन प्रेगनेंसी एक्ट, एमटीपी, जिसके अंदर लीगल और वॉलंटरी टर्मिनेशन की बात होती है. सेफ माना जाता है मेडिकली 20 से 24 वीक्स तक, डिपेंडिंग ऑन अदर स्टेट्यूटरी कंडीशंस एंड स्टेट वाइज रेगुलेशंस. ठीक है. और दो तरीके से होता है, मेडिकेशन बेस्ड हो सकता है या सर्जिकल प्रोसीजर के थ्रू भी हो सकता है. नाउ व्हाट इज द एमटीपी लॉ इन पर्टिकुलर? यहाँ पे आपके लिए दो चीज इंपॉर्टेंट है. फर्स्टली द फुल नेम ऑफ एमटीपी विच इज मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी एक्ट. ओके. Why it's called medical? Because the fact that it is medically supervised and the fact that it has to be medically approved also is why is the reason behind this name. That's the first question that you can expect. The second question could be that in which year this law came into force, that is 1971. And then there could be another law that in what year this was amended, so that is 2021. So see, these are some questions that can be formed around this concept. Now, with respect to time limits, so first is up to 20 weeks. If there is an opinion of one registered, one RMP, abortion can take place for whatever reason, for whatever ground. Okay, so up to 20 weeks, it is not a problem as long as you get one medical practitioner to approve it. Then for 22, 24 weeks, there is a specified categories of women, maybe rape victims हो सकते हैं या फिर special conditions हो सकती हैं. consent could be a problem for that women. जहाँ पे you need to have two medical practitioners giving consent for that kind of rape. Sorry, that kind of termination. Yes. लेकिन अगर स्टैट्यूटरी लिमिट से बाहर जाना है, इफ यू हैव टू गो बियॉन्ड 24 वीक्स, तो द लॉ हैज नॉट गिवन एनी specific circumstance in which you can go beyond 24 weeks, but the Supreme Court can do that in exceptional cases, like in this case, because the girl was a minor. How is it related to Article 21 or to the Constitution? Is because I said that you talk about bodily autonomy, right to live with dignity, personal liberty, ये सारी चीजें आती हैं आर्टिकल 21 के अंदर. ठीक है. तो हाँ, क्वेश्चन ये बन सकता है कि बॉडीली ऑटोनॉमी कौन से आर्टिकल के अंदर प्रोटेक्टेड है. ठीक है. आर्टिकल 21 के अंदर आती है. So that is what it is with respect to MTP. I think we will go through MTP in more detail with subsequent lectures, and then we have this law by Supreme Court which says false promise of marriage. When does it amount to rape law? So normally, if there is a false promise to marry, number one, and on that basis there is a sexual relationship for which the girl has consented, then, and number third, if the boy later on backs out or does not fulfill the promise, it can amount to rape in certain cases. But the court has given a clear warning that when there is a woman with a subsisting marriage, promise to marry a woman with a subsisting marriage, the man is already married to some other person, and the woman is aware of that. Let us say in a certain relationship, the woman is aware that this man is already married and maybe has kids, and she has still given consent for sexual intercourse, for a sexual relationship. Then later on, when the relationship fails, then the woman cannot complain of rape. That's what the court has said here. उसको फिर false promise of marriage नहीं बोल सकते, because that the woman was also mature enough. She knew what was right, what was not right, and she also knew that this it's impossible. It's not going to happen. It's unlikely. So when she knew the unlikelihood of the same, she cannot come up with a complaint later on, right? Now, that's why the proceedings under 376 IPC, which is about rape, they were quashed. To quash the proceedings means to discard the proceedings, to bring them to an end or to cancel them. यहाँ पे लीगल कॉन्सेप्ट क्या क्या है फॉर फॉल्स प्रॉमिस ऑफ मैरिज. I just explained that if the man has a false intention from the inception or from the beginning, and which the promise made the sole part of why the woman gave consent. I mean, the woman was under the belief that if she has intercourse with this man, then he will marry her. If you can establish that kind of depth and clarity, then yes, it can amount to rape, but not otherwise. So in this case, this was not proved properly or successfully. Okay. So even the complainant was legally married. Even the woman was legally married to somebody else. And therefore, the court said that they cannot help her. This cannot be considered to be a rape because the divorce was also pending and the marriage promise was unlikely from the very beginning. Okay, unlikely from the very beginning. So yes, we can say that in a way it also depends on the likelihood. If it is more probable that the marriage can take place, then the court might have given a different verdict, but that did not happen. Yeah, so the key facts are that the parties are aware of the subsisting marriage, and then because of that, there is no deception of consent, and yeah, the courts have given some judicial caution. That's not really important for us anyway. So this is the first part of Feb. The legal coverage that we found is relevant for you. We discuss a lot of legal GK questions also, potentially, which can be asked, even the passages. I hope you have made thorough notes of these topics. Do revise them every month. You can come back to these notes and revise. And soon we will also come up with more, videos on legal GK questions, on specifically on legal GK questions from the month of January and also February, right? So if you have already subscribed, then great. If you have not yet subscribed, then you must subscribe it without any delay, because this series is going to be very, very helpful for your examination. And do like it and comment, and also share it among your groups to uh, to help everyone with this video, with this series. And you can also drop in the comment box any feedback that you would want to give, any topic that you want me to cover in law, or anything else, any other kind of help that you need from us. Do let me know in the chat box, and then we'll definitely look into it. So I hope to see you all once again very, very soon. We are soon coming up with the Feb 2 part, and like I said, a specific session on legal GK. So don't miss that session. Okay. We will notify you in advance, but don't miss that at any cost. Right. So I'll see you all once again. I hope you like the session. Thank you so much. Thank you for your time. And I wish you all the very, very best for your examination. Thank you.